Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every other Friday, Alex Ooley of the Ooley Law Offices from Indiana. Alex, thanks for joining us today, man.
Yeah, great to be with you, Paul.
What I wanted to talk about today, I alluded to this story, and Amanda and I talked about it a little bit when she was on this past Wednesday. There was a decision that came down from the Supreme Court this week, and it was unusual for the Supreme Court in that it was a unanimous decision. This is a Rhode Island case. I'm going to draw a rough thumbnail, and I hope I get this correctly. Husband and wife having a fight, and he, being over melodramatic, in my opinion, takes out a handgun, lays it on the table, tells her, "Why don't you just shoot me?" And then wife leaves the house, leaves him with the guns. Next day, wife cannot get a hold of husband. He won't answer the phone. So she calls the police, asks them to do a wellness check. Police show up to do the wellness check. They tell him, "We'd really like you to go get checked out." He says, "Fine, under one condition. You don't come in my house. You don't take my guns." The police say, "We agree to that. That's fine." They take him to do the wellness check. While he's getting the wellness check, without a warrant, they get his guns, they take them. The man then sues. It eventually makes it all the way to the Supreme Court. Decision comes down this week. No, you can't do that. They were trying to say it was under community caretaking. Something like if you have a firearm in your car and the police discover it, they can take it. I'm not that familiar with that, but the Supreme Court says your home does not even come close to being the same as a car. Am I close to being right there?
Yeah, you got that. You summed up that case pretty well there, Paul. This case did come down last year, though, not this week. It has been in the news a little bit recently because of just general discussion around red flag laws. But this was decided last May, I believe, and you brought up this community caretaking notion in the law, and basically what happened here is, like you said, that the man agreed to do a wellness check. He went to be evaluated, and after he left the home to be evaluated, the police went in and seized his firearms, and they justified the seizure, the taking of his firearms, under this community caretaking exception to the Fourth Amendment. As most people know, the Fourth Amendment guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and that guarantee shall not be violated without a warrant, except a warrant based on probable cause. And here, the police justified the taking of the firearms on an exception to the Fourth Amendment called community caretaking. And the Supreme Court said, no, you can't do that. Community caretaking is for situations where maybe a police officer stops someone along the side of the road or notices someone broken down along the side of the road and needs to engage in some degree of intrusion to take care of the community for safekeeping. Okay, it's not part of an investigation. It's not a criminal matter. And they do not have to get a warrant to engage in those community caretaking functions. So the court here engaged in quite a stretch, the district court engaged in quite a stretch by saying that this was justified by the community caretaking exception to the Fourth Amendment. Luckily, Mr. Caniglia challenged that, he appealed, and the Supreme Court agreed that the seizure that took place here was not allowable under the Fourth Amendment. So what's interesting about this case is what impact it may have on red flag laws or extreme risk protection orders. Mm-hmm. And because it sounds a lot like a situation that may have been appropriate for one of those situations, for a red flag or an extreme risk protection order. Now, obviously, I don't advocate, I don't support red flag laws, but they've become popular in recent years, especially since the Parkland school shooting in Florida. Indiana has had a red flag law for quite some time, for well over 10 years, but they've become more popular recently. And this case is interesting, this Caniglia case, because Justice Alito, in a concurring opinion, Justice Thomas actually wrote the majority opinion, and it was a 9-0 decision, like you mentioned, which is unusual. Justice Alito actually sort of leaves open the door to challenges to red flag laws, because he says this case also implicates another body of law, that this body of law around red flag laws that states are enacting. And he says provisions of red flag laws may be challenged under the Fourth Amendment, and those cases may come before us. However, our decision today does not address those issues. So I think this case sort of lays some groundwork for some litigation around these red flag laws.
Yeah, absolutely. Get a quick comment in here. George just commented over on the YouTube side. He says, I guess the moral of the story is don't tell your wife to shoot you. The other moral is be careful about who you marry. So, yeah.
Yeah.
Well, and let's be honest, I mean, breakups of marriages are extremely emotionally charged. And people do stupid things both when they marry and when the marriages break up. And so you're gonna see stupid things happen.
Yeah, exactly. And that raises an important point about these red flag laws, that they're ripe for abuse. And there's an issue with due process with these red flag laws, because I believe, and I think a lot of listeners would agree, that red flag laws get due process turned completely upside down. Because what happens is, when someone makes an allegation, and this process varies state to state, but when someone makes an allegation that a person is dangerous to themselves or others, police can go and seize their firearms. And in Indiana, they can do that without a warrant, and in most states, these are going to be done without a warrant, or can be done without a warrant. Mm-hmm. But they'll go and take the firearms without a warrant, and then have to submit an affidavit within 48 hours justifying the seizure, supported by probable cause. So they get the probable cause after the fact. So there's one issue. Then the other is that once the firearms are taken away, and this is again in Indiana, the court has to conduct a hearing within 14 days. And at that hearing, the state is required to prove by clear and convincing evidence that the person is in fact dangerous and the seizure of the firearms was justified. The person whose firearms were seized is not likely to be prepared for that hearing within 14 days, because they'll likely want to obtain an attorney who will need some time to prepare. So they'll more than likely want more than 14 days to prepare and pay for an attorney. And then as a practical matter, once they do have that hearing, judges are going to be reluctant to return the person's firearms, because they don't want blood on their hands. They don't want to return firearms to somebody who could be the next school shooter. So judges, I believe, are going to be inclined to side on the side of the police and the person making the allegation, and err on the side of caution by maintaining the firearms from the person.
And talk about a tough job for the defending attorney on this, in this case, because you have to prove a negative. You have to prove the person is not a danger. That's a tall order.
Well, and technically, at the first hearing, the burden is on the state. So the person whose firearms were seized shouldn't have to prove anything. But you're right, Paul, as a practical matter, I think they do have to show that they're not dangerous. By law, they don't have to show anything, but as a practical matter, I think they do. With that said, If at that hearing the judge determines that the seizure was lawful, that the firearm should be kept, the person whose firearms were seized can petition the court after 180 days to have his firearms returned. But at that hearing, the petitioner has to prove by preponderance of the evidence that he's no longer dangerous. So the burden does shift at that point. If there's been a determination that you were dangerous and you want your firearms back, you have to prove by preponderance of the evidence, which just means more likely than not, that you're no longer dangerous. Now, with that said, after a year, so that's after 180 days, after a year in Indiana, this burden shifts back to the state to prove that you're still dangerous. So there is some due process protection built into the law here in Indiana. Some states, their red flag laws aren't quite as generous with respect to due process, but the problem is it's still the reverse. Your rights are taken, your property is taken, and then due process is given to you later. Okay, so that's exactly the opposite. The government is supposed to prove beforehand that you're a danger before they take your property. And red flag laws don't do that.
Well, and we are blessed with some extremely smart viewers and listeners. We got a comment that just came in from Charlie Chambers, and I don't know if you're prepared for this one or not, Alex. This is it's a rather deep one. He says, can you discuss the Baker Act and how, in my opinion, it's way better than red flag laws? Baker is due process and has existed for years.
I know, so my understanding, and I'm not familiar with the Baker Act, but I believe that's a Florida provision, so I'm not intimately familiar with that, and I could be wrong about that. But I think what Charlie is pointing out is that in most states, there are mechanisms by which you can get treatment through mental health commitments for individuals. So most states have mental health commitment procedures that serve the same purpose as the red flag laws, because let's face it, red flag laws are targeting what? One thing, firearms. Mm-hmm. And people who are truly dangerous can be dangerous in a number of ways without firearms. So most states have some sort of mental health commitment procedure. If they're really dangerous, there are provisions in place to allow those due process provisions through mental health commitment procedures to help that situation.
I know when we've discussed red flag laws before, I've brought up that I think on their face red flag laws are a huge mistake, simply because if this person really is mentally unstable and really is dangerous, you're taking one out of a myriad of dangerous tools away from this person. You're taking away their guns. That's true. You're leaving the keys to the pickup truck. You're leaving the gasoline can. You're leaving the axe. You're leaving a lot of other tools in their disposal, and you're leaving their freedom.
Yeah, exactly. And then what happens? They take the firearms, but then there's no other mechanism to help the person. These mental health commitment procedures try to fix the problem. And the only thing the red flag laws do is take away your guns. And they may be based on completely vindictive allegations that are totally unfounded. So they're ripe for abuse. They deny due process until after the fact. And the last thing is they're not really shown to be effective. I don't think there's any evidence to show that they reduce suicide, murder, aggravated assault, any of those things. As a matter of fact, it's a few years old now, but John Lott published a study, I think it was in 2019, that showed that red flag laws have no significant effect on murder, suicide, mass public shootings, robbery, aggravated assault, or burglary. So, as a matter of fact, I think the study showed that rape went up. Of course, that may have just been correlation and not causation.
Right.
But certainly, these red flag laws did not help.
Yeah, absolutely. The one other thing I wanted to bring up while we're talking about red flag laws is this, and it's Jeff Knox, when I interviewed him years ago. This has been early in the Polite Society podcast. We're talking probably 5 or 6 years ago. I remember Jeff Knox and I had a discussion, and one thing that came up was, and this is just as red flag laws were getting a toehold, that it is very common when there is a divorce that it's almost automatic that the husband files a the wife files a restraining order against the husband files a restraining order against the wife. It's almost automatic. Mm-hmm. And the concern was, well, going forward, that'll change from just restraining order to now red flag orders flying about. And for example, if the husband is a collector, or the wife, let's not be sexist, if one of them is a collector, the other one isn't, we could be talking about very expensive firearms that are, let's put it this way, delicate, and the police are not known for keeping good care of firearms over a 180-day period.
Mm-hmm. Yeah, no, that's right. That's a great point. In the family law context, you're right. They could be abused, and you could have red flag or extreme risk protection orders flying both ways. I haven't experienced that. I don't do much. Actually, I do almost no family law related cases here in Indiana, but I haven't heard that come up through other attorneys, at least not in Indiana. But that would certainly be a concern. And then with respect to, red flag laws, we pointed out earlier, they don't have much effect, if any. And so they don't achieve the purpose they're intended to achieve, and they deny due process. So I think that the purpose that they were intended to serve is totally outweighed by the denial of a right that's stated twice in the Constitution. Okay, it's in the Fifth Amendment and it's in the Fourth Amendment, and that's the right to due process. So I think the government should have to justify these with some data, and I don't think, or actually with significant amounts of data to deny the right to due process, and there's none.
I want to, because we've already burned up almost 2/3 of the time we have, I want to move up to our next story, and this one, this is Hawaii just being Hawaii and doing its worst. News story came out a few days ago. An officer in the Navy is going about things the right way, and the law says in Hawaii you need to register all your firearms. He's stationed there. He wants to bring his firearm to where he's stationed, and so he goes through all the paperwork. Part of that is going through the licensing and all that. He's denied his license because he was homesick and went to go see the Navy psychiatrist, psychologist or something, and because he was feeling homesick and a little depressed, not major depression, and all of a sudden Hawaii says, nope, you're mentally ill, you can't have firearms. And this is, Hawaii needs to be sued into oblivion. This is ridiculousness to the extreme.
Yeah, and this is an example of why the New York State Rifle and Pistol Association case is so important. The case in New York challenging the May issue licensing scheme in New York, because if a local bureaucrat has the discretion to approve or deny an application for a license to carry a handgun, that discretion is going to be abused, especially in these anti-gun jurisdictions. And this is a classic example of that, where they denied a permit, denied a constitutional right at the whims of a bureaucrat.
Oh, and this wasn't even a carry permit. This is a permit to possess. This is a permit for ownership.
Right. So that's even worse, right? Because as we know, the Supreme Court in Heller said that if you have the right to possess and own a firearm anywhere, it's in your home. And we believe certainly that right extends beyond the home, but the restriction should be justified by substantially more than this flimsy denial in Hawaii.
Yeah. I want to get a couple more. We're getting those comments are kind of, my software's been hit and miss picking them up. They're coming in a little quicker. Let me get a couple more comments in. Going back to the due process, Larry says, by creating due process, it's just an older way of the same thing, but it is in the law because equally abusable as any other false allegation that comes with an exigency component. My tongue is not working today.
But yeah, he's right to point out this exigency component. Due process is often skipped because of some justification by an exigent circumstance, and the court often upholds those. So even when, frankly, they shouldn't be.
George over on the YouTube side says King George III would have loved red flag laws. And back over to the Facebook side, Charlie Chambers says, by the way, one-party consent laws for recording are brilliant. My ex would threaten false accusations. I started recording her. Anyone that thinks Auschwitz is not possible has never married evil. My attorney said I was brilliant. Me, ex, and her attorney never appeared in court for my filing of divorce papers. There are mitigating options and truth. Okay. Then he also followed up with, she unfortunately grew mentally insane over the years. No hate here for her.
Yeah, I mean, there are certainly options to try to maintain your innocence or show evidence that you're not dangerous, but your right shouldn't be taken away, and you shouldn't have the burden of doing that. And that's the problem with these red flag laws, is it puts the burden on you if after that first hearing you're found to be dangerous. It puts the burden on you to get your rights back until at least a year after your rights have been deprived. And that, like I said, it delays due process to begin with, and a right delayed is a right denied. That's a pretty common saying.
Okay, one final story I want to get to today, and that is this. I knew this was in the works. I knew that there was a lawsuit that was going, but today a story hits. 22 state attorneys general file amicus brief in the Supreme Court case that is GOA is suing to reverse the federal ban on bump stocks. It's my personal feeling on the bump stock ban. I think it's wrong. I never did own one, and if the bump stock ban goes away, I'll guarantee you I will. I don't know that I'll ever put it on an AR, but I'm going to own one if the ban goes away. I don't. They're a fun toy, but that's about it.
Yeah, and I'm like you, Paul. I think they're a fun toy. They're not that practical, but nevertheless, I think this ban is crazy, and it should be overturned. And it's kind of like the First Amendment. I think people should have the right to say whatever they want to say, and if they want to say stupid things, they can say stupid things. And the same with products that may or may not be practical for use in self-defense or for use in hunting. But nevertheless, the ATF shouldn't have this rulemaking authority to just outright ban products that they deem to be malicious or dangerous or something. And it's not even through, what's so bad about it is it's through the ATF, who is this organization. It's not a legislative body. They don't. It's not composed of elected officials, and it just acts arbitrarily at the whims of the people who appoint them. So it's a horrible way to basically criminalize completely innocent conduct.
I know the people at FRT Triggers, Fast Reset Triggers. I know the people at FRT Triggers are really hoping this case has a successful outcome. That's another one that I do not own an FRT trigger, but should this go through, and I would seriously consider getting one. Again, I don't have a binary trigger. I'm very much a fan of Timney triggers, which I have on one of my 2 ARs. I like what works for me, and I don't get into a lot of the gimmicky stuff. But when the Justice Department attacks, when the ATF attacks it, boy, that makes me want it so much more.
Yeah, exactly. Yeah, I would have no interest in, I'm like you, Paul, I would have no interest in some products, but as soon as they're banned by the ATF, it's like, oh, maybe I should look into those. Yes.
Yes. All right. Anything on the legal horizon that I haven't brought up today you think we should be talking about?
We've mentioned it quite a few times, but it's April 8th already, so we should be hearing from the Supreme Court in the New York State Rifle and Pistol Association case soon. So I hope to hear some good news in that in the next couple of months, and that's going to be a big one. That's for sure.
Well, we heard, I think it was late yesterday, we do have a new Supreme Court justice coming in. She will not, however, be a part of that decision, will she? She gets sworn in the fall, right? That's
correct. Yeah, which is interesting because she avoided a lot of the questioning around during the hearings around her nomination. She avoided questions with respect to the Second Amendment because there was a case before the Supreme Court, and she didn't want to opine on issues before the court. But she's not going to take part in that decision. So that was an interesting excuse not to opine on that issue.
Yeah. Well, she also didn't take part in the decision if she knew on whether what a woman was, which I thought was asinine myself. But,
yeah,
you know, it's...
The only benefit to that, it was... I was disappointed in that answer, obviously, but there were lots of great memes that came from that. Like, I can't tell if something's a dog because I'm not a veterinarian or some sort of meme like that.
Exactly. All right, well, we're right down at the bottom of the hour, so that's about the time we have. Alex, always fun talking with you, man.
Yeah, great to be with you, Paul. Thanks for having me.
All right, folks, I do want to encourage you, join me at noon Central Time tomorrow for the weekly bullet, for the weekend edition of the bullet. Eventually, I'm going to be able to get it out. And a little bit of an update. We were splitting the weekend and weekday edition bullets and the Polite Society podcast over. Some of it you caught here, some of it you caught there. From here on out, all editions of the bullet and all Polite Society podcast broadcasts are going to be done right here on the Polite Society podcast page. All broadcasts move here. We're getting fantastic feedback over here, even better in some cases than over on the SAF page. And it's a lot of hard work, sometimes very quickly, to switch between SAF page and Polite Society podcast page. So I got the permission to go ahead and keep all the broadcasts here. So tomorrow, if you're watching, wherever you're watching, come back tomorrow, noon Central Time, and we will have the weekend edition of The Bullet. For today, thanks for watching, and come join us again tomorrow. Thanks for catching us, everybody.